All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Richard B. Orfinger, Chief Judge presiding. All persons having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Please be seated. Good morning and welcome to an oral argument session at the 5th District Court of Appeal. As the Deputy Marshal said, I'm Judge Orfinger, and I'm joined on the panel today by Judge Alan Lawson on my right and Judge Carrie Evander on my left. Judge Silvernail is not with us today. There's been a slight change in the calendar. The first and third cases, Davis versus Marion County and Koval versus Marion County, we have issued an order consolidating for purposes of oral argument, and so we'll argue those cases simultaneously, and I think our order indicated that we would permit 30 minutes per side instead of the usual 20. So let me just get the file out here. And with that, we'll go ahead and get started. If you have your cell phones on, we would appreciate it if you would turn them off so that the parties are not interrupted. And if you would like to reserve some time, please let me know, and I'll be happy to set the clock accordingly.
Thank you, Your Honor. I'm Richard Bennett, attorney for the appellants, and I would like to reserve 10 minutes for rebuttal.
All right, sir.
Your Honor, the appellant landowners in these three appeals sued to invalidate assessments for unauthorized road paving and won 4 times in court. Yet we're here today because, notwithstanding rulings that the assessment was invalid, the landowners have been reassessed and still have to pay for the unauthorized road improvements. We're asking the court to reverse 3 summary judgments that found that the reassessments were lawful. These appeals concern 3 questions, in our opinion. The first is, does repeal of the special act clear the way for a reassessment? And if so, does an assessment to pay a loan for unauthorized roads provide a benefit to the lands that is special and unique? And third, if so, does the enabling ordinance that authorized the reassessments actually do so? As to the first question, in 1985, the county sponsored...
Let me stop you a second. You said that and I was looking at the special act when you said that, because you said that the paving was unlawful. The county clearly had the right to pave the property. The only limitation would be under Special Law 85-467. They couldn't assess for it under that special law. Is that correct?
Your Honor, the special act limited road paving projects that are funded by assessments to the condition precedent that 51% first approved.
But I think the question was, if they didn't impose an assessment, if the county just wanted to pave the road out of its general revenues, it could have done that.
Absolutely.
Okay.
That's part of its
no question about
power. So there's nothing illegal about the paving.
No, the county does it all the time through their taxing powers, using ad valorem taxes or gas taxes or otherwise. But in the situation where a petition is sent to landowners in a subdivision and estimate a cost and ask the landowners if they will agree and approve an assessment to their lands to pave roads in their neighborhoods, when the proposal, the road paving proposal, is rejected, then any roads that are paved and assessments levied to fund the paving is illegal. And that's what the findings...
That's what the court found in the
And that's what the court found. In all the cases, in fact, Techington, the first case that was appealed by the county and is not before the court today, the judge ruled that the road assessment was invalid ab initio and void in its entirety. And Judge Lambert in the two cases that have been consolidated with this, the Koval and Smith cases, he held in his partial summary judgment that the county does not have the authority, home rule or otherwise, to improve these roads through assessments. The Davis Court also found that the assessments were unlawful.
Yeah, I guess where I'm struggling is I'm having a hard time seeing why the City of Seattle versus Kelleher and Prosper and Anderson versus City of Ocala and Moody, all those cases that say that you can go back and reassess, and that there's no constitutional impediment to assessing for something that's already built previously, and that a reassessment is generally valid, why those don't answer this question.
Because in this case, Your Honor, in those cases, the county had the power to do the roads, but executed the power in an irregular...
They had the power to build roads here.
Right.
Okay.
They had the power to do it, but with a road assessment program, they needed the approval of the majority of the landowners. And the Supreme Court in the
At the time that the assessments that we're here on today were made, they did not need that approval, because the Special Act had been repealed.
Correct.
Right?
Well, they did. Our point, Your Honor, is that in the 1930s, the Supreme Court of Florida held that where you need a certain amount of petitions to do a road paving, and the Simmons versus Fessenden and Hillsborough County versus Desir said that without the necessary petitions, the county had no power to proceed with the project. They were powerless without the consent.
And why wouldn't the 1968 Constitution in Chapter 125 change that? Because prior to the 68 Constitution, a local government could only do what they were expressly authorized to do, so that made some sense if you didn't have the power to do it. But under the current Constitution, the county and municipalities have broad home rule power, so they have the general power to levy assessments, the general power. It's not a jurisdictional issue in any sense under the 1968 Constitution, I wouldn't think.
Well, we think it's a special assessment issue, and the authority to reassess is based on the rule that you had to initially have the power. And the Supreme Court in the 30s said, without the petitions, you have no power to proceed. So in the Anderson case that they rely on, the county had the power to assess by ordinance, and they had the power to reassess. And the court ruled that the assessment
under the 68 Constitution, they don't need the legislature to tell them that they have a power to assess or reassess. They have the power to do it, unless there's a provision of general or special law that says they don't.
Well, they went to the county after the refunds were apparently going to be ordered. They went back to the legislature, and they wanted the legislature to validate the assessments that had been made contrary to the requirement that 51% approve. And the Local Affairs Committee substituted the bill and took out that language and only repealed the act. And we believe that the basis for that was that...
if the legislature had done what they wanted, then the county commission would not have had to assess. Again, the legislature would have validated the assessment.
Would have fixed it.
Right.
But the rule in Florida is that a validation act cannot validate a lack of power in a county to act in the first instance. And that was the Broward County versus Plantation Imports case, citing a Supreme Court case, Beatty versus Inlet Beach, because curative laws can heal irregularities in action, but they can't cure a want of authority to act at all.
I guess the basic difference of view is, in the county's view, after 1968, any procedural hurdle that's added by special act is a procedural issue, because they have broad home rule powers that allow them to make assessments, make reassessments, build roads, do anything that they want that's lawful. And in your view, somehow that's even after 68 a jurisdictional issue.
Well, it was jurisdictional because they didn't have the power to assess originally, and the rule in Florida is you can't fix a lack of power to initially proceed. So when the act was repealed, the question is then, is the application of the act prospective, or can it be applied retroactively to adversely affect the rights of the vested rights of the people at the time they voted not to be assessed for these road improvements?
Let me ask you this. Hypothetically, let's assume there had been no initial assessment. So there's a request for roads, but they don't think they're going to get the 51%. They have the special law out there. So while they're seeking, requesting the legislature to repeal the special law, they go ahead and build the roads, borrow the money, build the roads. And then the law does get repealed. Can they then do a special assessment?
You mean without a vote in the first instance?
Let's assume that vote never took place and there was no assessment. They built the roads while they were waiting for the special law to be repealed.
Right.
Special law, they build the roads, special law gets repealed, and then they do their special assessment.
Okay, but there was no petition process. The county just elected to build a road. I think that would be similar to the Keller case, where you build an improvement that benefits properties and then later assess the owners, and that's been held to be lawful. But
okay, so if the first assessment was a nullity, why wouldn't we be in that same situation here, as my hypothetical? If you just don't count that first assessment, then we're dealing with the hypothetical I just gave you.
Because the rights of the people vested when they had the exclusive power to decide under the special act whether they wanted to be assessed for this particular road project. And in this project, they voted no. And the county had restricted their home rule power and given it over to the people to decide. And under the law that existed at the time the roads were proposed to be paved, they voted on it and rejected it. So why isn't that a vested right for this road project not to be funded by assessments? How can the county then adversely, by a later act, adversely affect the rights of people who had the power to decide whether they wanted their lands assessed? And they said no. So then how can you ignore that and say it doesn't matter at all what happened? We're going to just assess you for these same road improvements that when the law provided you the power to decide, you decided against us.
Help me understand why you think that the rights were vested and that the county could not act contrary to that vote once the law was repealed. I mean, it seems to me that governmental entities, they turn down a zoning request, and then, a year later there's a new city commission or county commission and somebody tees it up again, and this time they approve it. I mean, I'm not quite sure that I understand your vesting argument.
Okay, well, this court in 1985 in Ross versus Roberts Construction dealt with the repeal of an act as to amount of attorney's fees that could be awarded in a case. They got repealed during the pendency of a case, and at the end of the case, the prevailing party wanted fees in excess of the limitation that had been repealed. And this court said that you can't apply the repeal of an act retrospectively to adversely affect the vested rights of the parties at the time the lawsuit was commenced. And that thinking is the same thinking we're using here. What was the point of the county going to the state legislature to give the power and effect to the people to decide an issue if all they had to do 25 years later was repeal it and say, your vote under the state law at that time is now meaningless. And whatever rights you had not to be assessed for this road, we're just going to ignore that and assess you by a reassessment that doesn't really benefit your property at this point.
I mean, you do recognize that under the case law, the roads benefit the property.
I understand that, Your Honor, but I understand that a special assessment here has to benefit the property by some unique and special benefit. And the finding to support this reassessment was that it improved the use and enjoyment of real property by funding the construction. We submit that funding, paying the county loan, in other words, with an assessment, doesn't improve or your use and enjoyment of roads, which you rejected and did not authorize and were illegally constructed. So now, what is the benefit to the property by an assessment to pay a loan? There's no logical relationship between the use of the money to pay a loan and the benefit to the property.
Is there any, because it logically doesn't make sense to me, but is there any case law that suggests that the mean of financing determines the legality of the assessment? In other words, you have to directly take that cash and go pay contractors for the road, or it's illegal?
Not if you had the power to build the road. And our contention is they didn't have the power to build the road initially and assess it. The road project was rejected.
I thought you agreed they did have the power to build the road.
They could have built the road, but not under the special act where you ask the people you've given the power to. Their home rule power was restricted. They could not build the road. That's what the cases say. They had no authority to proceed.
Just so we're clear, I think we're confusing the power to build the road and the power to impose an assessment. If they did not want to impose an assessment, but just pay the cost out of other county revenues, you concede they could have come in and built the road.
Absolutely.
Your contention is not the road building itself, but the assessment for the payment.
Well, it was the project. The notice to the people in all these cases said, we propose to repave your roads at a cost of, in Lake Tropicana, $5,000, where before the people paid $35 a year and still pay it, that funded construction of unpaved roads. $35 a year.
Well, would
it
restrict the county if they had sent those letters out and said, we'd like to pave these roads and assess everybody $5,000, and everybody, 90% say no? Could the county still come in and pave the roads? Under your belief, could the county come in and pave the roads and not assess the people? In other words, just pave the roads. Everybody may have said, we want to live on a dirt road, but the county says, well, we're going to pave the road anyway. Right. As long as they don't make them pay for it other than as a regular taxpayer. Could they have done that?
Yes. But what they did was said, we're going to create an MSBU, and the MSBU is going to pave your roads, and it's going to cost you $5,000. And in fact, 83% said no. This is horse country. They didn't want the traffic. They like riding their horses there. They didn't want it. It was overwhelmingly rejected. And
how do you, though, distinguish the cases that Judge Lawson mentioned earlier, several U.S. Supreme Court cases that validated reassessments? I mean, if we accept your argument and we accept the finding of the court, as I think we do, that the initial assessment was invalid, what's to prevent them, once that act was repealed, why don't the Supreme Court cases that Judge Lawson mentioned earlier validate a reassessment?
Because they all had the initial power to do it, and they did some irregularity. Just like the model that their ordinance was based on was the Municipal Statute 170-14 that said any error or irregularity could be corrected by another assessment. And that assumes you had the power in the first place to assess. And if you just did it wrong and there's some technical violation, you fix it because of the benefit there and some moral obligation of people to pay for benefits that improve their property. But that's not the case here. You don't find any reassessment cases where there was no initial power. What did the special act mean if it didn't give the people the power to decide? And once they decided, how can government then change the rules after the fact and apply it retrospectively to impose an assessment that was rejected initially? And in this case, the assessment was actually not authorized by law. The county repealed the law, the ordinance, this 97-4, and replaced it with a new ordinance in 2009. And the new ordinance said at Section 310 that if an assessment made under the provisions of this ordinance is annulled, vacated, or set aside by the judgment of any court, this board could impose a new assessment. Well, none of these assessments were made under 0910. There's no provision, no authority granted in the ordinance that was used to impose these reassessments for an assessment invalidated under the prior ordinance, which was repealed. It wasn't amended and restated as the county states in the final resolutions. It was all recognized that the prior ordinance was repealed. And without authority to make an assessment, there could be no assessment made. I'd like to reserve the balance of my time, Your Honor.
All right, sir, you've got 11 minutes.
May it please the Court. My name is Greg Stewart of the law firm of Neighbors, Giblin, Nickerson, Tallahassee, representing Marion County. As the Court noted, the issue in this case simply is whether the county has the authority to reassess for these road improvements in 3 recorded subdivisions within Marion County. In each of these, the trial court ruled that based upon the special acts, the initial assessment failed to get the vote count that the special assessment or the special act required, which was 51% of all property owners as opposed to those that just voted. The sole basis of the trial court's rulings in each of the 3 cases was that the amount of vote, the vote requirement, was not reached, and the special act therefore required that the assessment be invalidated. In each of those, once the special act was repealed, the county reinstituted reassessment procedures, went through the entire process, individually mailed notice to each of the property owners, published notice, adopted the final and an initial assessment resolution, and imposed the reassessments for these road improvements. Now, the power of a local government to reassess in the event that there had been an initial assessment invalidated is well established. And Judge Lawson referenced some of the cases that we have cited, and there are others. It's well established, and I think the appellant concedes that that case law is there and applicable. The argument that they are making is that somehow the requirements of the special act are jurisdictional in nature and not procedural, and therefore a curative legislative act, a reassessment, would not be permitted. That argument is without merit. It's important to recognize that the requirement of a vote and a particular level of approval is not a jurisdictional requirement. It's inherently procedural. And as such, once that requirement was eliminated and the special act repealed, the county had full authority to reassess under its wide spectrum of powers. And in looking at the requirements, it's important to recognize, first of all, what is the county's authority generally? And how was that authority modified by the special act? Now, normally when you talk about a jurisdictional requirement, it goes to the fundamental authority of a county to act, as opposed to a procedural requirement, which is how that power needs to be exercised. And in this particular case, the county, different than prior to the 1968 Constitution, has a wealth of authority granted to it to impose special assessments both under its home rule power and under its express statutory grants of authority, can do assessments in a wide variety of ways.
Let me ask, just on the assessment issue, let's assume that these roads had been in there for 5 years and there was no dispute over, the county just put them in without making any assessment. 5 years down the road, the county says, you know, we're a little tight on money, so we put these roads in 5 years ago. We think that they are a special benefit to the people who get to use them every day. We're going to go in and do an assessment, and these roads are probably good for another 20 years, so we'll spread out the cost of the road over the next 20 years. Can the county do that?
Well, I think the county ultimately has the authority to impose the assessments, and without being locked into the 5 years, there is a point in time when the benefit from the road, the special benefit, is diminished. And so the argument would be that the specialist benefit requirement of the special assessment is not met because, let's say, the road is now already worn down and we're just trying to get additional revenue. But from a powers basis and from the authority of a county to impose something, they have the authority. Under certain factual situations, it might be problematic. But it would be problematic not in the sense of their authority to act, but whether an assessment 10, 20 years down the road for an improvement that was provided back in 2000 or 2010, whether there is a special benefit derived from that roadway. That would be the analysis, I believe.
So in this case, the reassessment occurred how long after the roads were?
The reassessment was in 2010. The roads were built in 2008, 2009.
So would it be your contention that even in the absence, let's assume that there had never been the original assessment that had been determined to be invalid, would it be your view, and if so, on what basis, that the county could still come in at that point and do an initial assessment, special assessment for the people who use those roads?
I think that the benefit from the roadway has been given to those people. I think it has been built. They are receiving the special benefit, and that is the essential test of a special assessment. Special benefit, fair apportionment. And I think that clearly within the parameters that you're talking about in your question, those properties are getting the benefit of that roadway. And now that there's a delay in their payment. Frequently, you'll see in wastewater, water assessments, that cities and counties will go ahead, build the plant. They will go ahead and have it all built. That may take several years. And then they impose an assessment to those properties for that cost. That actually is generally deemed more beneficial to the property because they have the use of the road or the water treatment plants, and the operations are in effect before they have to start paying. But in that circumstance, the benefit they're getting is from a road in front of their house, or in my analogy, the wastewater or water treatment plant. Now, in this particular case, the addition of the vote count requirement is, once that was repealed, the county had its full authority to proceed under whatever powers it had. And as Judge Lawson indicated, and I think it is fundamental to understand that counties operating at post-1968 have broad home rule powers. And the test is, as Judge Lawson indicated, whether in fact there is express prohibition by general or special law. There is no prohibition from a reassessment in general or special law. And the counties have the ability to impose those assessments. Also, the ability to impose assessments without statutory authority can in fact be done under their home rule power, and in fact has been upheld. Now, and also under general law authority, and I think this is important too, counties are given a wide variety of means to proceed. They can build roads and provide other improvements and services, but they can build roads and they can do them within a municipal service benefit unit under 125.011Q, or a municipal service taxing unit, or a special district, or they can do a special assessment without any of those mechanisms. All of those authorities and powers are available to the county, and they were not impacted by this special act. What this special act did was, it was not a grant of power, it was a limitation on the county's powers. And it required, under very limited circumstances, that in fact you had to go through this vote count procedures. In those circumstances, it had to be a road improvement, it had to be within a recorded subdivision, it had to be within a municipal service taxing unit, and it had to be on a per parcel, per acre, or per structure basis. If those applied, then the vote count provision of 51% of the property owners applied. The county could have gone and done this assessment and done it on a front foot basis, and that special act would not have applied. They had the authority under all of their home rule powers and all their statutory authority to proceed, but the special act required, under this limited circumstance, that they in fact had to get 51% of the property owner's consent.
How do you counter the argument that once the vote failed, that the property owners then had some vested right, in essence, to fend off the ability of the county to assess their property for the road?
I think, first of all, if in fact there was some type of vesting of right, first of all, you would never have a reassessment case, because that vesting argument would apply that you had tried, you didn't do it correctly, therefore you cannot try again. In this particular case, because it is a procedural requirement, and only a procedural requirement in these limited circumstances, the county still had its full authority to do it. And once that requirement was eliminated, it could start again, and that's exactly what it did. It started again, went through the entire reassessment process, and imposed the assessments in this case. There is no vesting right, and there is absolutely no case law that I've ever seen that gives property owners a vested right because of a failed assessment attempt.
You want to address the argument that the use of bond financing somehow changes the analysis in, I guess, Kelleher and other cases? In other words, now the bondholders paid for the roads already, and now if you reassess, you're only benefiting the bondholders and not the property owners to the adjacent road.
Almost all public improvements that are funded by special assessments go towards the payment of debt. What happens is that they're going to build a road, they're going to build a wastewater treatment plant, they borrow money from a bank, they issue bonds, whatever the financing mechanism may be. And they then pay that over time with special assessments imposed on an annual basis. And those go to pay the debt service. The manner that a particular project is financed is not the benefit test that is analyzed. It is the project itself, the improvement itself, and whether that improvement provides a special benefit. And I'd refer the court to the City of Boca Raton versus State case, which is a bond validation. There were special assessments imposed.
And those were the circumstances in that case, but the court doesn't expressly address this argument that somehow maybe it wasn't raised, I don't know, that the assessment's going to help the bondholders, not the.
I think that you can logically say, well, then the assessment is going to help the construction worker who is being hired to build the roadway and not the property. There is benefit, obviously, from the building of a road and that it extends on. But the primary benefit, the most distinct benefit, is to the property owners themselves, because they pull out of their house and they are now on a paved road. And the fact that those payments are going to repay the money that was advanced to build that road is not a factor in analyzing the benefit. In this particular case, there has never been an issue concerning the benefit to the property owners. That has been conceded by counsel throughout this case, and I'd refer the court to the transcript before Judge King in the Davis case, and I think it's page 32, 33, where there's a detailed discussion of exactly this issue about the benefit derived by the property owners. If, in fact, they derive a special benefit, they can be assessed for that improvement, and that is exactly what has happened in this case in the reassessment. And I think the issue concerning the prior approval, prior construction, I think that's been pretty much resolved over the years. That went all the way back to the Kellar case. That was raised initially, and it was raised in the Anderson versus Ocala. The mere fact that it was a prior improvement does not diminish the fact that the county can, or the city in those cases, can reassess, because the benefit is derived by the property owners. Unless there's any other questions, we'll rely on our briefs for the remainder of the arguments. We would like ask the court to affirm the decisions of each of the three trial courts on these cases and uphold the reassessment that has been imposed by Marion County. Thank you.
Thank you, counsel.
Judge Lawson,
hold on just a second. I messed up the clock. You've got 11 minutes left, and somehow I have managed, hold on just a second here. to have to take a new course on this. All right. I think we're in good shape.
All right. Thank you. Judge Lawson, in 1886, the U.S. Supreme Court in Ziegler versus Hopkins said, a petition from the owners of a majority in frontage of the property to be charged with the cost of the improvement was necessary to set the machinery of the statute in motion, and no step could be taken under the provisions of the statute until the requisite petitions have been presented. Now, the Florida Supreme Court followed that ruling in Simmons versus Fessenden and said the statute requires as a jurisdictional prerequisite that the petition be signed by the owners of 2/3 of the property abutting that portion of the street to be improved, and until a petition be signed as presented, there's nothing for the city council to act upon. In Hillsborough County versus Desir, a 1935 case, the Supreme Court of Florida held that a statutory petition signed by the owners of 2/3 of the abutting property was a jurisdictional prerequisite to paving assessments. The jurisdictional prerequisite petition not having been filed, the county commissioners were never vested with authority. And that's our argument. One, that without the necessary petitions that are required by the state law, the county could not act to go with a road project and build the road and assess the owners. We're being assessed for the same roads that the county had no authority to proceed with. This isn't a procedural irregularity that can be fixed by repealing a statute with nothing more. Because the repeal
is okay. I mean, you keep going back and saying they had no authority to build the roads because of
to
the
be
vote.
funded by assessments. That was the road project. That's what the special act addressed. Give the people the right to decide if they want to be assessed for a road project. The people rejected the proposal, and the county nonetheless paved the road and borrowed the money. So just repealing an act does not then give them authority to later come back and say, your decision made when you had the power to make it for these roads, which we built without any authority to go forward, is now your obligation. And we don't care that 4 times courts ruled that we couldn't do this. Well, now we're going to do it, and we're going to take away your rights retrospectively. These were property rights that the owners of the lands received under the state law not to be assessed for these roads. And they're being assessed for these roads. And the cases that all say in general, if you had the power and you didn't do it exactly according to the procedure set forward, well, you can go back and fix it because of the benefit. What if I came to your house and said, Judge, your house needs to be painted. If it got painted, it would improve the value of your property and everyone else's property, and it would be a benefit to you, and it would make your house, more presentable and a better for the whole community. And you said, absolutely not. And I said, but it's a great price. I'll do it really cheap. I'll do it for the cost. I just don't want your house, to look like it looks. And you said, absolutely not. And then when you're away one weekend, I paint your house. And you come back and say, why did you do that? I didn't want it. And I say, well, you just got a benefit, Judge. You owe me the money. You got a benefit. You can't deny that your property's been benefited.
Bad example. I live in a condo and that just happened. I didn't think it needed painting. They painted it and now I pay for it.
The point is, the benefit is sort of irrelevant to my authority to proceed and to do things for you that you don't want. And the county felt strongly enough about giving the people the right to decide that they made it a state law. Now, why would they do that? Why would the county make a state law restricting their power to assess people for roads? Because they never could tell at public meetings and hearings whether a majority wanted it or a vocal minority was there, pushing one point of view. So to settle this question once and for all, we'll ask the people, we'll give them petitions, and if they don't come back a majority, we won't do anything. We won't consider it. We won't go forward. We have no authority. Our hands are tied now by a state law that prohibits us from doing any road improvements and assessing them for you. So for 25 years, that was the law, and they violated it. So finally, the landowners prevailed on that question. And now just repealing the law, we can go back in time. And this petition at Rainbow Springs was done in 2005. And now in 2010, their vote is being annulled, and they're being assessed for exactly when they had the exclusive power to decide, it's now being overturned. What are the rights of the property rights of landowners when they act under a state law that vested them with the exclusive authority to reject the county's attempt to pay themselves back for a road that they borrowed funds for that they should have never built? The county should pay for when they violated the law. They should be responsible for the cost of the roads that shouldn't have been built. How can you assess the same people who rejected it the same amount? In fact, they're worse off now because they got refunds, less fees, and now they're being assessed the whole thing again. So by going to court and prevailing, they're worse off now than if they would have not done anything at all. What is the point of the justice system if you can call the county accountable for their illegal, unauthorized acts only to be assessed again? The Utley case, another Supreme Court case, said it's well settled rule that a tax levy which could not have legally been made cannot be ratified, and that when resulting in a violation of substantial property rights, a void tax levy cannot be legalized. Well, that's what they've done here. The county has, in effect, legalized their illegal act. They just said, that doesn't matter. You got something similar to the house painting, and now you're going to pay for it. What are the rights of the people when they have rights under state law that are taken away by the county? And not even, and Mr. Stewart did not address this, under a valid ordinance that permits them to levy this reassessment. You heard nothing in the briefs or from Mr. Stewart in his answer that this ordinance that the courts found authorized the reassessment actually does that, because it doesn't. There is no power of reassessment given in County Ordinance 0910. Thank you, Your Honor.
Thank you, sir. Thank you both. Well-argued case.